My name is Larry Swikart. I am co-author of A Patriot's History of the United States with Michael Allen and founder of the Wild World of History website, www.wildworldofhistory.com. And we are continuing our discussion of the United States Constitution. I'm going to discuss with you today Article 3 on the judiciary power of the United States courts and judges. And the authority of the courts in the United States Supreme Court especially was a point of real contention between the Jeffersonians, known as the Republicans, and the Federalists. And Jefferson wrote to Abigail Adams, for example, in 1804, "Nothing in the Constitution has given them, the federal judges, a right to decide for the executive more than to the executive to decide for them. The opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves, but in their own sphere of action, but for the legislature and executive also in their spheres, would make a judiciary a despotic branch." So clearly Jefferson opposed the judiciary powers outlined in the Constitution. However, Jefferson wasn't at the Constitutional Convention. Instead, his ally, the father of the Constitution, James Madison, argued vociferously for an even more activist Supreme Court. Madison envisioned the court actively participating in legislation, having, as he said, quote, "the authority to examine every act of the national legislature before it could operate and every act of a particular state legislature before a negative thereon should be final." He called this prior involvement of the judiciary. Can you imagine that? The court actually step by step telling Congress, no, you can't do that. That would be unconstitutional. Or, yeah, you can do that. That's okay. In our own times, people often grumble that the Supreme Court will not take a certain case largely based on hypothetical future harms. I discuss this below in the concept called ripeness. Madison obviously lost on this prior involvement issue. Moreover, Madison, who was the most prescient founder to foresee the rise and necessity of political parties or factions, also, even though he disagreed with it, observed that the Supreme Court would be, well, supreme. Madison wrote, "In the state constitutions, and indeed in the federal one also, no provision is made for the case of a disagreement in expounding them. And as the courts are generally the last in making their decision, it results to them by refusing or not refusing to execute a law to stamp it with its final character. This makes the Judiciary Department paramount in fact to the legislature, which was never intended and can never be proper." Jimmy, buddy, you designed the Constitution. You set it up that way, right? So Madison doesn't like this, but he doesn't have another answer. So it could never be proper, but de facto, if the courts are, quote, "generally the last in making a decision regarding disagreements," that gave them the final word. So when in Marbury versus Madison in 1803, Chief Justice John Marshall established the principle of judicial review of legislation that Madison had warned about, there it was, the fulfillment of what he feared. But again, how could it be argued? Barring a new constitutional amendment, any legislation denying the court's authority to rule yea or nay on any given subject could itself be ruled unconstitutional by the court. See how that works? It's a catch-22. Madison seemed to realize he had put the nation in a box, but offered no way out. Interestingly, however, the concept of judicial review lay dormant for almost half a century before it was energetically applied again. So let's look at the Constitution and what it says or doesn't say about the judicial branch. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So, there's no minimum or maximum number of justices stipulated. In theory, the U.S. Supreme Court could have one judge or it could have 21. Note that there were no other courts ordained and established at this time. This was due to the view that the state governments were still in control. Today, by the way, we have over 800 federal judges. The founders' concern was that the presidents with connections could get their fingers into every corner of the judicial pie in every part of the nation. Have we not seen that? We've had judges in Hawaii blocking actions by President Donald Trump on the mainland. The compromise to this was that the Supreme Court would be the final arbiter of the law of the land and what the Constitution itself meant. Even though federal judges were supposed to have lifetime tenure, this would go through extensive screening to become a judge. We today have many officials who work for administrators or administrative agencies or bureaus who are themselves essentially judges. Officials like this will rule, for example, on whether or not a company has used advertisements that deceive consumers, or a business has wrongfully tried to prevent its workers from joining a union, or the government has not paid a person the disability benefits to which he or she is entitled. Thousands of decisions of this kind are made every year by federal officials who are not considered judges. It is done so for purposes of Article 3, and therefore do not have lifetime tenure, but who do have different kinds of things judges usually do: settle disputes between people. These administrative officials usually serve only for a few years, after which the president can replace them. There are safeguards to prevent officials of this kind from being openly biased or unfair, but because they are appointed, and appointed so frequently, they are often thought to be more responsive to day-to-day politics than judges are. Although in theory, we can appeal the decisions of these quasi-judges and officials, the courts, over the years being overloaded with work, have just assumed that these officials, what they do, is constitutional, and have only asked the question, are they, these officials, these bureaucrats, following the rules of the agency that was created? This has become a national disaster because there is no check and balance on what is now called the administrative state and the numerous officials, bureaucracies, quasi-judges that now operate within this administrative state. Section 2. What follows is a discussion of the operations of the federal courts, the state courts, how they can independently create their own judiciaries and create their own rules, selection of judges, the scope of powers, and so forth. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and the treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies which the United States shall be a party, to controversies between two or more states, between a state and the citizens of another state, between citizens of different states, between citizens of the same state claiming lands and grants of different states, and between a state or the citizens thereof and foreign states, citizens and subjects. In other words, the judicial power of the United States shall extend to all cases in law and equity arising under this Constitution, the laws of the United States. Well, There it is. Nothing that follows limits in any way the authority of the U.S. Supreme Court to define law. Congress almost immediately created 13 district courts and some smaller circuit courts in 1789 with the first Judiciary Act. By 2021, there were 850 federal judges. Any one of these can tie up national legislation or presidential action with an order and cause all activity to halt with what is called a stay or an injunction. Article 2 of the Constitution authorized the president to nominate judges of the Supreme Court and lower courts with the advice and consent of the Senate. Now, there's a great controversy as to whether this enables the Senate to either act on nominations or to prohibit them from holding office. We've just assumed that it's been that way, but it wasn't always that way. Once appointed, judges are forever, sort of like diamonds, only losing their seats due to malfeasance or criminal behavior. Nor can their compensation be reduced. No budget was stipulated in the original article. But over the years, Congress provided for the construction of courthouses, even a national administrative office and judicial center for the courts. So back to the article. In all cases affecting ambassadors, other public ministers and consuls, and those in which the state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. In other words, the Supreme Court has original jurisdiction, first jurisdiction, over certain kinds of cases, meaning those cases, contrasted with all others, can start in the U.S. Supreme Court. For example, cases between two states, controversies against the U.S. government, or between citizens of different states, these all start in the Supreme Court. Also, the U.S. Supreme Court has, quote, original jurisdiction in cases involving government ambassadors and ministers. But there's some disagreement over Section 2, which says that the Supreme Court, quote, shall have appellate jurisdiction both as to law and fact, with such exceptions under such regulations as the Congress shall make. This exceptions and regulations clause has given rise to disputes over the extent of congressional control over the Supreme Court and its appellate jurisdiction. For example, can Congress pass a law saying U.S. Supreme Court cannot review certain kinds of cases? Abortion, homosexuality, and same-sex marriage? That's still being debated. In 1793, the Supreme Court ruled the trial of all crimes except in cases of impeachment, which be by jury, and such trial shall be held in the states where said crimes have been committed, but when not committed within any state, the trial shall be at a place or places as the Congress may by law be directed. Jury trials and federal prosecutions have to take place in the state where the crimes are committed. This harkens back to the Declaration of Independence and the concern that Americans were being transported overseas to England to face trial in England, where they almost certainly were going to lose, right? All convictions for treason must have testimony for at least 2 witnesses or a confession in open court. It's interesting. This is from the Bible. 2 Corinthians 13:1, that by the mouths of 2 or 3 witnesses let every word be established. Whether the federal courts hear a case depends by and large under the statutes under consideration, and 5 questions are asked when determining whether or not a federal court should hear a case. They are, first, whether the jurisdiction is exclusive, meaning that cases can be filed only in federal court, or whether the jurisdiction is concurrent with state courts. A second consideration is what kinds of cases fall within the description A third consideration is about whether Congress has to give jurisdiction or whether the Constitution automatically provides it and what kinds of limits Congress can impose. A fourth type is whether, once the federal courts have jurisdiction, that authority also provides them with the power to decide the underlying obligations of the parties. The fifth question focuses on remedies. What are the powers of Congress to limit or expand the remedial authority of the courts? And it is here we get into what I was talking about in another session called ripeness. Courts don't want to listen to hypotheticals, because when you listen to hypotheticals, not only are you going to have to start laying out possible lines of argument, but you also have to start laying out possible remedies to something that hasn't even happened yet. And they absolutely don't want to get involved in that. And we saw that heavily in 2020 and 2021 when a number of elections cases were being brought before these courts and a lot of hypotheticals were being involved. It had to be proved, for example, that whatever had happened in the state's voting system could have shifted the election from Donald Trump to Joe Biden. And since nobody could absolutely prove that, the courts just tended to throw these out. There are also considerations that all federal courts seem to apply at almost every step of the way. First of these is something I mentioned, ripeness. This is the notion that a case must be ripe for a decision. Is it really affecting anything right now? Courts, especially the Supreme Court, do not want to get involved in hypotheticals, how something might turn out in the future. A second major issue in determining whether or not to accept a case or reject it is standing. This recently has been horribly overused against American citizens to deny genuine appeals by saying you aren't the injured party in most of these election cases. But in a federal election, folks, any American citizen should have standing because we are all affected by federal elections. Needless to say, the courts have not seen it this way. On many occasions today, federal courts defer to other specialized agencies, which I mentioned before. These specialized courts, maritime courts, for example. Today, these specialized courts are extremely powerful and difficult to control. Again, they aren't elected. They are almost always appointed, and the Supreme Court has tended to say that these agencies are allowed to determine for themselves what their scope of authority is. As long as it's in their founding paperwork, they can do whatever they want or claim they can do whatever they want. In other words, the federal court system has tended not to look at the constitutionality of the agency itself, but how well it obeys its own rules. While all the debate about the direction of the courts certainly isn't over, it seems that more Americans than ever don't trust the court system to right the wrongs of either the executive branch or the legislative branch. And even more, the perception is that the Supreme Court in particular has tried to dodge critically important or incendiary cases such as election laws, vote fraud, and abortion. And that's Article 3 on the judiciary. And I am Larry Schweikart, co-author of A Patriot's History of the United States and founder of Wild World of History at www.wildworldofhistory.com.